In this week's module, we're going to take a closer look at some of the various gap filler provisions of UCC Article 2. By gap filler, we mean the various provisions of the UCC that supplement the parties' agreement with relevant terms in the absence of the parties' express agreement on those terms. Gap fillers thus fill in the gap in the parties' contract, where the parties' agreement does not address a specific issue, but that issue is relevant to the parties' legal rights or obligations under the contract. Gap filler provisions of Article 2 fill in the gaps in the parties' contract by supplying a relevant term to address the issue. Gap fillers are important because, as we have already seen, the UCC, like the common law of contracts, recognizes that parties may form a contract in any manner sufficient to show agreement. Thus, an agreement may be reached formally through a written contract drafted by attorneys and signed by both parties, but it may also be reached informally. For example, an agreement may be made orally or simply through the parties' conduct, any manner that manifests the parties' intent to be bound to a deal. The more informally an agreement is made, however, the more likely it will be that the parties will leave some important issues relevant to their deal unaddressed, unresolved, or indefinite. But remember, subsection 3 of 204 says that the parties may form a contract even though they leave one or more material terms open or undefined, that is, indefinite. This rule makes good sense because when parties engage in a bargain, they naturally focus their time and attention on the most important terms of the deal: what is being sold, how many, and for how much. The parties may not think to address less important details. For example, delivery and payment terms. When is delivery due? When is payment due? What happens if the goods fail to conform to what the buyer asked for? If the law required contract parties to address every single possible issue relevant to their deal before a legally enforceable contract is formed, the law would hinder the ability of parties to make and enforce contracts. And thankfully, the law does not require this level of detail. Instead, subsection 3 says that so long as 1. The parties intended to make a contract that is intended to be bound to a deal, and 2. There is a reasonably certain basis for determining the parties' rights and obligations so that a court can determine whether there has been a breach, and if so, what is the appropriate remedy for that breach, a contract is formed between the parties. It does not matter that the parties' agreement leaves open or indefinite one or more details. So all that is required to form a contract is an intent to be bound to a deal and some reasonably certain basis for determining what the terms of that deal are. Let's take a look at these individually, starting first with the intent to be bound. Remember, even though the intent to be bound is a subjective state of mind, the common law of contracts, and therefore the UCC relying on the common law, uses an objective test for intent. The law looks only to objective evidence to determine intent, objective manifestations of the party's intent based on outward observable words, conduct, or action. Objective evidence of subjective intent could come in a variety of forms. The best objective evidence of the party's intent is the express words used by the parties. Language is more precise, less ambiguous than other unwritten nonverbal forms of communication. Naturally, the express words of the parties, whether orally or in writing, is the best indication of what the parties intended. Indeed, I like to call language the gold standard for determining the party's intention. Did the parties' words manifest an intent to be bound to one another to some kind of transaction, or manifest an intent to something else? Beyond the language used by the parties, courts might look to other objective factors to ascertain the party's intent, and in particular, whether the parties intended to be bound to a deal. For example, the relative definiteness or indefiniteness of the agreement between the parties. Even if the parties agreed to some basic outlines of a deal, the existence of open or undefined terms that leave significant matters relevant to their deal unaddressed or undefined suggests that the parties are still in the process of negotiating, in the process of clarifying their intentions as to what the deal would be. Indeed, the more material the terms are that are left open or undefined, the more likely it is that the parties did not yet intend to be bound unless and until the parties are able to come to a definitive agreement on those terms. Likewise, the existence of a signed writing could indicate an intent to be bound. Although signed writing is not required to create an enforceable contract, the formality of preparing a written agreement and then signing that agreement is a deliberative, purposeful, objective outward action. It's not the kind of thing that individuals normally do unless they intend to be bound to whatever is specified in the writing. Therefore, signed writing is typically strong evidence of the party's intent to be bound to a deal. Finally, if one or both parties begin performing their respective part of the bargain, The act of performance itself is objective outward conduct that suggests the party performing believes she was legally bound to an agreement. Note a similar intuition animates the part performance exception to the statute of frauds that we covered in an earlier module. In that context, where a buyer makes and the seller accepts payment, or where the seller delivers and the buyer accepts the goods, either situation, the party's actions in performance of an apparent transaction provides an evidentiary basis to believe that the parties actually agreed to some deal, even though there's no written evidence of that agreement. That brings us to the second requirement under subsection 3, which says that so long as the parties intended to enter into a contract, it does not matter that the parties leave certain questions unaddressed, provided there is a reasonably certain basis for determining the parties' rights and obligations so that a court can determine whether there has been a breach, and if so, what is the appropriate remedy for that breach. This is where gap fillers come into play. Where the parties' agreement has left one or more issues undefined or unaddressed, for example, when, where, or how the goods are to be delivered, the gap filler provisions of Article 2 can fill in the gaps left open by the parties' express agreement, thus providing a reasonable basis for determining the rights and remedies in the event of a breach. In this respect, you can think of Article 2's gap filler provisions as merely default rules, rules that bind the contract parties in the absence of the parties' agreement otherwise. You may have encountered the idea of gap fillers in your study of the common law of contracts. Under the common law, so long as the parties intend to be bound and the parties have, through their manifested intent, agreed on the material terms of their deal, most importantly price, with reasonable certainty, the court may fill any remaining gaps in their agreement with a term that would be reasonable under the circumstances. The UCC, by statute, provides a number of default terms to fill in very specific types of gaps that may be left open in a party's agreement for the sale of goods. So far in this course, we've covered 3 other concepts that function like gap fillers but are not quite gap fillers. First, the implied duty of good faith. Remember, this duty is implied into every agreement, but it's not really a gap filler, it's more of an interpretive tool used to interpret the express terms of the parties' agreement. The implied duty is more of a presumption that in the absence of language to the contrary in the parties' agreement, the parties intended to act in good faith and consistent with standards of commercial reasonableness. The second concept we looked at that are sort of but not quite gap fillers are course of performance, course of dealings, and usage of trade. These are not gap fillers, though. These are actually part of the parties' agreement. That's because of the way agreement is defined under the UCC. Remember, the definition of agreement means the bargain of the parties in fact as found in their language or inferred from other circumstances, including course of performance, course of dealings, and usage of trade. By expanding the definition of an agreement to include custom, the UCC limits the need to resort to statutory gap fillers, because gap fillers only come into play where the parties' agreement, that is, the parties' express language as supplemented by custom, is silent on a particular issue. Stated differently, applicable course of performance, course of dealings, or usage of trade will always take precedence over statutory gap fillers where there's a conflict between the two. And this makes good sense because course of performance, course of dealings, and usage of trade to varying degrees reflect what we think the party's intent was. In contrast, statutory gap fillers are not in any sense based on what we think the parties intended. Instead, they're just a bunch of legal default rules. The third concept that we have looked at in this course that operate like gap fillers are the implied warranties of merchantability and fitness for a particular purpose. Indeed, these are the closest things that we've looked at so far that operate like other gap fillers of the UCC. Like other gap fillers, these warranties are implied into the party's contract in the absence of the party's agreement specifically disclaiming these warranties. But the implied warranties are gap fillers that apply only in special situations. Reflecting their distinctive policy purposes, each warranty is implied into a contract only if certain preset conditions are true at the outset. In this week's module, we'll look at 3 specific categories of gap fillers that may apply to any contract for the sale of goods. Gap fillers concerning quantity of goods, the price for the goods, and delivery and payment terms.